Hello everyone. Today we are doing second chapter Forms of Business Organization. A business enterprise is an institutional arrangement to form any business activity on the basis of ownership. Business enterprises can be broadly classified into the following categories. First is private enterprise. It is owned, managed and controlled by a private person. Public enterprise owned, managed, and controlled by government. Types are departmental undertaking, statutory corporation, government company. Third type is joint sector enterprise, owned, managed, and controlled by private and government enterprises. Private enterprise can be sole proprietorship, partnership, joint Hindu family business, and corporate form is cooperative society and joint stock company. So children, there are different types of the private enterprises. This diagram is also very important. Now sole means only, proprietor means owner. So sole proprietor means a form of organization in which there is only owner of business. He himself manages and is only receiver of all profits and losses. Features of sole proprietorship. Single ownership. He is the sole owner of all the assets and resource of business. Second point is no separate legal entity. From legal point of view, the business has no separate existence or entity. That of the business. All the assets and liability of the business are that of the businessman. Third point is no legal formalities. No legal formalities are required to start, manage and dissolve such business organization. Fourth is control and management. Sole proprietor has full power to control and manage such organization. Fifth is unlimited liability. The liability of the owner is unlimited. In case the assets of business are not sufficient to meet its debts, the personal property of owner can be used for paying debts. Six is undivided risk means owner bear all the losses and enjoy all the gains. It is suitable for the personalized service and small scale activities like agriculture, job of stitching, bakery, beauty parlor. Secrecy. All the important information concerning the business resides only with the owner so that no outside party can take any undue advantage of it. The merit of the sole proprietor is easy formation, second is quick decision, third is secrecy, fourth is direct motivation, fifth is personal touch. The limitations are limited financial resources, limited managerial ability, third is unlimited liability, fourth is uncertainty, fifth is limited scope for expansion. Suitability, where personal attention is required to the customer, like tailoring, beauty parlor, where goods are under standardized, like artistic jewelry, where modest capital and limited managerial skills are required. Business where risk is not extensive, that is lesser fluctuation in the price and demand, that is stationary shop. Second point is joint Hindu family business. It is owned by the members of undivided joint Hindu family and managed by the eldest member of the manager or a family known as the Karta. It is governed by the provisions of the Hindu law. The basis of membership is birth in a particular family. The common properties include there should be at least two members in a family. Second is ancestral property to be inherited by them. Hindu Succession Amendment Act 2005 allow women to become co-partner as well as karta of joint Hindu family business. Now features. First is formation. There should be at least two members in a family and some ancestral property to be inherited by them to form this type of business. Second is membership. Membership automatically starts by birth in the family. Third is control. In this business, it is managed by the karta only. The other members can suggest him only. Fourth is liability. The liability of the karta is unlimited, but for of all other members limited to the extent of their share in the property. Fifth is permanent existence. The existence of permanent like the existence of the company. There is no effect of the death, insolvency, or lunacy of the members of the business. Sixth is minor members. A minor can also become full fledged members of the family business. Seventh is registration. There is no need of any registration. Merits, effective control. Second is continued business existence. Third is limited liability. Fourth is secrecy. Fifth is loyalty and cooperation. Limitation of joint into family is limited capital. Second is limited managerial skill. Third is unlimited liability. Fourth is unbalanced decision. Now next topic is partnership. According to Indian Partnership Act 1932, partnership is the relation between persons who have agreed to share profits of a business carried on by all or any one of them acting for all. Characteristics of partnership: more than one person. Second is agreement. Third is profit motive and sharing of profit. Next is decision making and control. Fifth is unlimited liability. Sixth is lack of continuity. Seventh is principal agent relationship. It means every partner plays double role of an owner and an agent. Merits of partnership is easy of formation and closure, large financial resources, balanced decisions, sharing of risk, secrecy. And limitations are limited resources, unlimited liability, lack of continuity, lack of public confidence, lack of harmony. Types of partners. Partnership at will. This type of partnership exists at the will of the partners and continue for unlimited time. Particular partnerships are: this type of partnership is formed for specified objective and comes to an end after accomplishment of objective. General partnership: liability of partnership is limited and joint. Each partner participates actively or in the business and registration is optional. The continuity of the business is affected by the death, lunacy, insolvency, or retirement of a partner. Limited partnership: liability of at least one partner is unlimited, whereas the others may have limited. They do not have right to manage business management. Registration is compulsory. Continuity of limited partnership does not get affected by death, lunacy, or solvency of the partner with limited liability. Now, types of partner. First is active partner, contribute capital, participated in the management of firm, share its profit and losses, unlimited liability. Second is sleeping or dormant partner, contribute capital, does not take part in day-to-day activities of the business, share its profits and losses, unlimited liability. Next is secret partner, contribute capital and is known to the general public, participate in the management of the firm, share its profits and losses, unlimited liability. Next is partner by estoppel, do not contribute capital, but by his words or conduct impress other to be partner, do not participate in the management, Do not share profit and losses, unlimited liability. Next is partner by holding out. Do not contribute capital. Do not participate. Do not share, unlimited liability. Nominal partner. Do not contribute capital. Do not participation in management. Generally do and share its profit and losses, unlimited liability. Minor partner. Do not contribute capital. Do not participate in management. Share in profit and not in the share its profit and not the losses. And last is unlimited liability. That is regarding the minor partner or partner below the age 18. Next is partnership deed, the written agreement of a stamp on a stamp paper which specify the terms and condition of the partnership is called the partnership deed. Generally, it includes name and address of firm, name and address of partner, duration of partnership, scope of business, contribute of capital by partners, profit and loss ratio, terms related to the salaries, drawing interest, and interest on drawing of partners, duties and obligation of partners, terms governing admission, retirement, and expulsion of the power, method for solving disputes, valuation of goodwill. Registration of partnership is not compulsory, but it is always beneficial to get the firm registered. The consequences of the non registration of firm are as follows. Number one, a partner of an unregistered firm cannot file suit against the firm or the partner. The firm cannot file a suit against third party, and the firm cannot file a case against its partner. Next topic is cooperative society. Cooperative, co means together and operative means operate for the motive of welfare. Co means together, cooperative, and operative means for the motive of welfare. Features are voluntary membership, legal status, registration is compulsory, limited liability, control lies with the managing committee, service motive, cash trading, government control, and arrangement of finance. They can arrange finance from the sale of shares to members, loans obtained from the government. Merits of cooperative societies are easy of formation, stable existence, limited liability, and supply of goods at a cheaper rate, government support. Now, limitation, shortage of capital, inefficient management, lack of secrecy, and excessive government control, conflict among partners or members, lack of motivation. Types of cooperative societies are consumer cooperative society, producer cooperative society, marketing cooperative society, farmer cooperative society, credit cooperative society, and cooperative housing society. Next is joint stock company. It is a voluntary association of persons having a separate legal existence, perpetual succession, and a common seal. Its capital is divided into transferable shares. Features are incorporated association, separate legal existence, perpetual succession or existence. It means death, insolvency, and insanity or change of members has no effect on the life of the company. It can come to an end only through the prescribed legal procedure. Limited liability, transferability of share, common seal, separation of ownership and control. Next is merits are limited liability, transfer of interest, perpetual succession or existence, scope of expansion, professional management. Limitations are legal formalities, lack of secrecy, lack of motivation, delay in decision making, oligarchic management. It means companies said to be democratically managed but actually managed by the few people, that is board of directors. Sometimes they take decisions keeping in mind their personal interests and benefit and ignoring the interests of the shareholders of company. Types of company: private company and public company. Private company. According to section 2 in bracket you will write 68 of Companies Act 2013, a private company means a company restrict the right of the members to transfer shares, restrict the number of the members between 2 to 200, excluding present and previous employees of company who are members also, put a ban on inviting the public to subscribe to its shares, put a ban on inviting public to subscribe to its public deposits. Fifth point is must have a minimum paid up share capital of 1 lakh rupees. Public company. According to section 2 in bracket 71 of Companies Act 2013, a public company means a company which is not a private company. A public company is one has no restriction on the transfer of shares, has no maximum limit of members, has no restriction on inviting the public to subscribe to its shares and debentures, has no restriction on inviting public to subscribe to its public deposit, has a minimum paid up capital of 5 lakh rupees. Now, difference between private company and public company. Name: private company, private limited. Public company, it has to write only limited after the name. Number of members, minimum 2. Private company, maximum 200. Public, minimum 7, maximum no limit. Directors, minimum 2 directors. Public company, minimum 3 directors. Private company, minimum paid up capital 1 lakh and public 5 lakh. Invitation to public: private company cannot invite public for issuing shares and debenture. Public company can invite issuing its shares and debenture. Freedom: no freedom to transfer share, no restriction to transfer share. Now, index of members: not essential to prepare an index of members. If number of members exceed, then it is necessary to present index of members. Index means just like a attendance, like the registration. Next is commencement of business: after getting certificate of incorporation, after operating, commencement of business. One person company is not in your syllabus. Now, formation of a company, very important topic. Formation of a company means bringing a company into existence and starting its business. The steps involved in the formation of a company is promotion, incorporation, capital subscription, commencement of business. Promotion: identification of business opportunity, feasibility study, name approval, fixing up signatories, appointment of professional, and preparation of the necessary document. Next is incorporation. It means registration of the company as body of the corporate under the Companies Act 2013 and receiving a certificate of incorporation. Steps of incorporation. First is memorandum. First is application for incorporation. Second is you have to file certain documents: memorandum, article, statement of authorized capital, consent of proposed director, agreement with the proposed managing director, statutory declaration. Next, payment of fees, registration, certificate of incorporation. Next stage is capital subscription. First step is SEBI approval. Second, filing of the prospectus. Third is appointment of the bankers, brokers, and underwriters. Next is minimum subscription. According to the SEBI guidelines, minimum subscription is 90% the issue amount. If minimum subscription is not received, then the allotment cannot be made and the application money must be returned to the applicants within 30 days. Next is application to stock exchange and allotment of the shares. Next stage is commencement of business. And to commence business, public company has to obtain a certificate of commencement of business. For this, the following steps or documents have to be filled with the registrar of the company. First is a declaration that 90% of issue amount has been subscribed, a declaration that all directors have paid in cash, a statutory declaration that the above requirement have been completed and must be signed by the director of the company. Important documents are Memorandum of Association. Contents of memorandum are name clause, situation clause, clause, and liability clauses and capital clause. Article of Association for the internal management of the affairs of the company, and the articles define the duties and powers of the officers. Contents of articles are the amount of share capital of different classes of shares, right of each class of shareholder, procedure for making allotment of share, procedure for issuing share certificate, procedure for forfeiture and reissue of the forfeited shares, rules regarding casting of the votes and proxy voting, procedure for selection and removal of directors, dividend declaration and payment related rules, procedure for capital readjustment, procedure regarding the winding up of the company. Next is prospectus. Main contents of the prospectus are company name, main object of the company, the number of the classes of share, qualification shares, the name and address of the director, minimum subscription, the time of opening and closing the subscription left, the amount payable on the application and allotment, underwriters and merchant bankers. Statement in lieu of prospectus. A company having a share capital may sometimes decide not to fund from the public because it may be confident of obtaining the required capital privately. In such a case, it will be have to submit statement in lieu of the prospectus. Now, difference between memorandum and articles of association. Memorandum define the object of the company. An article define the rules attaining the object in the memorandum of association. It is a principal or main document. Article is the subsidiary document. The activities beyond the power of the MOA are not considered to be performed by the company. Activities beyond the power of the AOA are also void. Defines the relationship between the company and the outsider, and it AOA defines the relationship between the members of the company. Necessity, it is preparation is necessary to get the companies registered, means MOA is compulsory, but AOA is also not like that compulsory, but they can adopt the public company rules, and it cannot be easily altered. Memorandum, but article can easily be altered. Now, choice of form of business organization is not in your syllabus, so don't do it, children. So there is no point. Just till formation of the company procedure you have to do, and the differences between articles, memorandum, these things you can do it easily. Thank you very much for listening.